Rick's with doing some drafting, but it is, I think, appropriate that before we embark on actually trying to reach conclusions about how we make things better in this Commonwealth for children, that we hear from judges and others who deal directly with both dependent and delinquent children. I believe that it is appropriate for me to introduce Sandra Moore, who is the head, I'm not sure the proper title, Office of the Office of Children and Families for the Administrative Office of Pennsylvania Courts, specifically for the Pennsylvania Supreme Court. And Ms. Moore, if you will introduce our panel.
Sure. Thank you all very much for giving us the opportunity to come and speak with you. I'm real excited to introduce the panel today, and I have to sort of go forward and look at how they sat because we didn't have an order here, but right to my immediate right is Marianne Berger. She is the Children Youth Administrator for Blair County. Next to Marianne is Judge Dwayne Capriva, who is the President Judge for Blair County. Next to Judge Capriva is Judge Joy Reynolds McCoy, who is the judge that does dependency work in Lycoming County. Next to Judge McCoy is Rick Saylor, who is the Children Youth Administrator there in Lycoming County. Next to Rick is Mark Cherna, who is the Human Services Director for Allegheny County. He also is the Children Youth Director. And next to Mark, and a number of other directorships, but next to Mark is the Administrative Judge for Family Court, Judge Catherine Hens-Grieco. Do you want us just to start?
Well, the floor is yours, however you would like to make this presentation.
So we have packets that we provided to the task force, and in those packets, this is PowerPoint presentation. Also included in the packets are some flyers that give a little bit more information about my office, about the work of the State Roundtable, the Mission and Guiding Principles document that was created by the State Roundtable, adopted by the Department of Public Welfare, the Juvenile Court Judges Commission, and the County Commissioners Association back in 2009. And we also provided you with CDs of the Dependency Bench Book and the Dependency Bench Book Resource Companion, which were created by State Roundtable, actually a subcommittee of the State Roundtable, group of about 15 trial judges and one appellate judge who created those documents as training tools for new judges and for attorneys practicing in dependency work. So I'm going to click through some screens, and I should say that our discussion as we were presenting this is that we hoped, and we weren't sure how you all function as a task force, but if you have questions as we proceed along, feel free to ask us. So what we decided might be most helpful is to give a brief overview of dependency court in Pennsylvania and what dependency court is like and what it means, and then to talk about the court improvement, which is a federal process that's happening here in Pennsylvania. And then we did provide county-specific data that the task force asked us for. And then we have thoughts and suggestions about what we think is working well in the current system and what might be some ways to improve the current system. So with that, the blue document in your packet, the mission, the booklet, blue document, is the Mission and Guiding Principles document that was created as a joint effort of the State Roundtable, which included children youth administrators, child advocates, parent advocates, and judges who sat down back that started the process in 2007 and thought, what is this thing we call dependency system really about? What's our mission? What are our values? What do we believe in? And what do we think is important for children and families who enter the system? And these are the four overarching goals that we believe are important in the dependency system. But again, I thought first maybe you should hear a little bit about dependency court. And I realize that some of the people on the panel are very familiar with dependency court, but in the past five or so years, dependency court itself hasn't changed dramatically, but how things happen in dependency court has changed pretty dramatically. So I believe Judge McCoy is going to talk a little bit about dependency court.
Good morning. In the dependency court system, it is really a very small percentage of children who come in contact with the child welfare system that actually come before the court. for any type of a proceeding before the court. The majority of children who are touched with the Child Welfare Service, it happens before that, and in most cases are diverted from ever having to come before the court. That is because we have the ability to get voluntary services in place once referrals are made, to get involved and engage the families and interact with the families with the hope of ever diverting them from having to come before the courts. Unfortunately for the courts, what that means is we see the most severe cases that wind up before the judges. Through the dependency proceeding, the participants that we have are the most critical participants are the parents, who are represented by a parent attorney, and every parent is provided an attorney. And when we have parents who are separated or not together as a family, they each have their own attorney representing them. The child, who is a critical part of the process and age appropriate participate in the entire process, who have a guardian ad litem, who is their counsel, they're representing them through the entire proceeding. We have the petitioner, which is generally the agency, the person who brought the petition before the court, and you have their solicitor, along with the caseworker, and many other people from the agency who participate in all of the hearings. And either a judge or a master, depending what county you're in, is presiding over the proceedings. One of the unique qualities of the dependency court system is that everyone who is there is focused on the child and focused on doing what is best for this child and hopefully ultimately reuniting this child with their family and working with the family. The goal is to provide them with guidance and tools to get them back to reunification. It's much different than the criminal system, where the purpose is to determine if you're guilty, many times by a jury, determine if you're guilty, and then punish you for that. In the dependency system, if we find that a parent has abused or neglected their child, it isn't that we now punish them because of that. What we do is put in, give them all the tools, the resource, the guidance, help them work through the system with the ultimate goal of hopefully reuniting the family together. And if we can't reunite the family together, the second best thing is to place the child with some type of a kinship placement, or to ultimately get them to permanency if it's not going to work out with the family or kinship. The function of dependency court really comes down to a fourfold. We protect children, we promote strong families, we promote child well-being, and we provide timely permanency. And I just want to talk to you a little bit about those four aspects. All children have the right to be protected from abuse. And we protect those children who are without proper parental care and control, do not have the proper parental guidance to provide for their physical, emotional, educational, or moral well-being. We protect those children who have no parents. We protect children who are habitually truant from school or habitually are incorrigible, have those actions. We however, do all this while trying to balance the trauma that comes along with a child being abused or neglect, the trauma a child experiences from being taken from their family. Promoting strong families is critical to the process. When you help a family, you help a child. And the goal is to keep children with their family if possible, if not with their actual parents with kinship, to have family input throughout the entire process, to provide the family with the tools to help them in the areas where they're lacking, to engage the entire family in the process. We don't just talk to the parents and leave it at that. It's, we engage grandparents, we engage aunts and uncles, anyone in the family who can step up and help that family, we engage in the process and encourage them to be part of it. The next is to promote child well-being. We look at not only the child's physical and emotional well-being, but their educational well-being is a critical part of the process. It is important to keep a child connected with family, whether it's their parents or if their parents are not part of the process, aunts, uncles, some connection so that they have that connection that is so critical to children to be connected to something. We also assure visitation so that parents, while they're going through this process, if their child has had to be removed, we continue that bonding with their parents by providing visitation. Also work on keeping siblings if not in the same home, that they have their visitation with their siblings. And also concentrate on older children who are getting ready to perhaps age out of the system, so they've got the skills that they need to move on after their involvement with the system. And lastly is to provide timely permanency. We recognize that parents are the first choice, and if it's not going to work, then kinship is the second choice, and if not, we need to get children to permanency as quickly as possible. That is the most important, is for them to feel safe and secure in the home that they're in and know that it is a permanent situation. And as I stated, the goal with the entire dependency court system is to keep children safe and in a loving, permanent home as quickly as possible.
And next we thought that it might be interesting for the task force, important for the task force to hear about the judge's role, because what the judge's role is in dependency court is different than a judge's role in other types of court. And I believe Judge Capri was going to speak to this.
Good morning. I'd like to thank you all very much for this opportunity to address you, but first I want, as a citizen, thank you. I mean, I'm sitting here looking at all of you knowing that you're volunteering, and this is impressive as a citizen of Pennsylvania to know that this many people are coming together to talk about children and care about that, and that's very impressive. So thank you very much for giving your time and your busy schedules. The role of the judge in dependency court has changed radically, and I feel like I'm a recovering judge, because I'm old enough to have been in the old system and now moving into the new system, and it has just been so wonderful to learn so much and be able to understand that we can do things differently and better outcomes. And I love Justice Baer's comment, maybe some of you have heard it already, but the old system was sort of like going home and telling your spouse or partner, what you think they did wrong, what's wrong with them. And then say to them, this is how I think you need to fix it too. He said, and then see what kind of night you're going to have. It's not going to be very productive, and it's not going to be very helpful. So if we don't act that way or, reason that way with people we love, why do we think that that system will work with people that don't even know us and that we don't know them? And what I've seen in the past was that the judge's role was to preside over this adversarial hearing and make the ultimate decision about people's lives, which was very difficult, very time-consuming, and it was very unrewarding. I mean, you really ended up feeling like you made more of a mess than what you started with. In the end, with all these new practices and changes, what has occurred is that you remove from the adversarial system. Not because it's a bad system, but just that it doesn't play well with the life issues that you're really trying to deal with. And so, it needs to remain in the criminal justice system. I'm not advocating that the whole adversarial system be disbanded, but in this arena, it makes more sense to have more of an organic experience, I call it, in the courtroom as a judge, where you are getting the facts, getting the information, but get it in a different format. So what you do is you say to the parties, I now have this 12-month review. This is the summary that was provided to me by CYF. Is there anybody who wants to contest any fact that's in there, or would you stipulate that, in fact, if called to testify, this is what CYF would say is their opinion or their facts. And if everyone says yes, then you move on and say, okay, well, assuming CYF said all that, now provider, tell me, how's mom doing with parenting? And mom, tell me how you're doing with your mental health. And you begin to turn the hearing over to the participants who want to know that it's about them, that it is not about the system, it is about them. And that's the new role that the judge plays in the system, is where you are inviting in that voice, that conversation, not disbanding your ultimate decision. I mean, there are times that even in that process, the end result is we are changing the goal to adoption. You haven't done what you need to do. So there is that accountability woven in there and ultimately there. But what you are doing to get there is have more of a humanistic approach. That this is not as easy as saying, you know, you either did this right or you did this wrong. There's a lot more to it. Just one slight example to just finish up, and that would be, you know, in the past, before I was a recovering judge, I would say, how many visits were scheduled for this parent? You know, or the testimony would come in, 16 visits scheduled. CYF worker would testify, and they only attended 7, less than half. Oh, well, of course, the assumption is they don't care about the child. But with judges learning about grief and loss and learning of the evidence-based practices, the next question can be, why? Why didn't you visit? And when you start asking that question, that's when you hear the response. Because every time I had to leave, it tore my guts out. I know it's my fault. The kids are in care. You know, now that's a different impression of that parent than they just don't care. And so it opens the door to a deeper understanding of why people do what they do, why they've made the decisions they've had. So you have an opportunity to get to the root causes. That's the goal, get to the root causes, yeah.
I'm sorry. to interrupt you, but
Please
I have a
do.
question. Is there, I know that foster parents don't have any legal standing in independent support, but in this new model, is there a role to hear from foster parents?
Yes.
How children are doing? And
Yes, everyone in the courtroom at the beginning, there's a sign-in sheet, and I come in and I ask them to raise their hand, I welcome them, and I say everyone will have a voice here, including the foster parents. So what has unfolded in my courtroom in a very organic fashion is that actually there's a connection between the foster parent and the birth parent. They're talking back and forth. We've had wonderful outcomes with birth parents providing information to the foster parents. We have seen the ability for the Act 101 to develop the birth parent would say, I've never met that person. You know, my child is in their home, and you know, I don't know them. And so I say to the foster parent, are you willing to have a visit with the birth parents? Yeah, we're open to that. And they get to know each other. You know, they introduce each other, or I hear wonderful stories about their co-parenting. The birth parent is actually talking to the foster parent on a regular basis. And so we're seeing outcomes of voluntary terminations because these connections are being made. There was no room for that connection in the adversarial system. It didn't invite it. But in this new process, it invites it, it creates it, it grows it. And that's what's very, very powerful.
Judge, can I just interject with Dr. Christian's comment? There's a statutory provision that while it doesn't provide standing to the foster parents, it requires them the right and ability to appear and be heard. So there is that statutory
Which is
protection.
relatively new.
It is.
It did not always exist.
And if I may,
So we don't want to take that away.
Right.
That's a good one. If I may interject, we have the advantage of you, in our previous hearings, we've had name tags, but this is, I guess, for our retreat, we've gotten to know each other. Perhaps we could introduce ourselves. Mr. Ipock, if you could start.
Judges, I'm going to say something you don't hear often. It was all my fault I was late. I take full responsibility and I apologize. I'm Gary Ipock. I'm the director of the Glen Mills Schools in Glen Mills, Pennsylvania, and see you nodding your heads.
Thank you, Glenn Mills.
I'm Rachel Berger. I'm a pediatrician at Children's Hospital of Pittsburgh.
I'm Delilah Rumberg, the CEO of the Pennsylvania Coalition Against Red.
Ed Macra, Deputy Secretary of CYF.
Dave Heckler, I'm the district attorney in Bucks County.
I'm Cindy Christian. I'm a pediatrician at Children's Hospital of Philadelphia and the medical director for the Department of Human Services.
Art Grimm, juvenile court judge in Berks County.
Bill Strickland, President and CEO of Manchester Bidwell Corporation in Pittsburgh. We work with inner city children in distress.
Good morning, I'm Jason Kudalakis. I'm an attorney with the law firm of Avon Kudalakis, primarily headquartered in Carlisle.
Good morning, I'm Jackie Bernard, I'm a prosecutor in Floyd County. Good morning, my name is Carol Pachado, I'm a social service manager with the Department of Human Services in Commonwealth.
Thank you. Our staff chooses to remain on.
Vicki Wilkins, Senate Republican Counsel for the task force.
Thank you. I think Judge Caprivi does a nice job at sort of emphasizing the change in really beyond practice culture of the dependency court. But sort of leads into the next slide, and that is there are some guidelines in what still has to happen in dependency court. And Judge Henscreek was going to speak to that.
So what you see up on the slide are the major statutes and federal statutes and statewide statutes that are touchstones for what we do in dependency court. But as Judge Caprivi has stated, a lot has changed in the manner in which we conduct business in dependency court based on a statewide conversation about what are best practices so that kids actually achieve permanency and have better outcomes while they're with us, and not that they're just with us for a period of time and then they go away somewhere else, perhaps to not a good place or whatever. We wanted to do it better. Well, there were 67 different ways of doing it. There were 67 different sets of rules. Every county did it differently. And so now there are statewide rules of juvenile procedure, which never really existed before, as an attempt to basically pull in not only the touchstones of what we needed to do, but what are the best practices around the country that we could actually put into rules so that what occurred for kids, the outcomes would be better. So the Supreme Court has, I think, 9 rules committees. They're made up of volunteers. They're volunteered by the Supreme Court to the committee job. And most people are very willing to take on that role. They meet at least quarterly, but the Juvenile Procedural Rules Committee, after the Luzerne County situation, started meeting monthly to actually develop rules for the state so that what happened in the courtroom really reflected best practices. What happens in those rules committees is there are lawyers and judges, and I'm on the juvenile procedural rules and domestic relations procedural rules. And they're from all over the state, because it doesn't make sense to make room for Allegheny County. It may work very well in Allegheny County, but it may have absolutely no validity in Philadelphia or a tiny Cumberland forest. So what we're doing is we're trying to balance what needs to be done with what would be helpful for the entire state. Rule changes are proposed and they're published for comment. This is a really important part of what rules committees do. We sit around and we argue and argue and argue for 2 days until we get down to something that we think is appropriate for the state, and then it's published. And then people send us, well, this is what happens. The next meeting we get one of these, and in it will be, multiple letters from people who have something to say substantively about what the impact would be if we actually had this rule. So our job is to advise the Supreme Court. So then we send it up after the publication, we revise it again. The Supreme Court again does another review and chooses whether or not to adopt it or to modify it. Very, very helpful for you to know, because in terms of what we do, we have changed how the courtroom works. And I'll just give you a couple of important changes. You see a few of them up there: placement stability, sibling placement, educational stability. I want to talk about one that's not up there, which is really important, and that is children in court. Children are mandated to be in court now, and that has changed the dynamic tremendously. Now, you wouldn't think you'd want little children in court, right? I mean, because long waits, they're complicated, what are they listening to? But really, the fact of the matter is these children have lived this situation, and they correct the mistakes of the adults in court. So if a caseworker or a parent is saying something, that little 8-year-old pipes up right on the microphone and says, no, that's not how it went, And besides that, it's incredibly important for the decision maker to see the well-being of that child, to see the relationship that happens with the child when they walk in the courtroom, to see who they're with and who they seek out for comfort. And so it's explaining to Mark in our 3-hour ride up here, to see the dynamic between the children, the siblings, and the parent is incredibly important to the judge. But other than that, it never used to be a part of what we had to do to say to ourselves, did we provide for sibling visits? Are there actually in that court order, did we say that child needs to see their sibling? Or wait a minute, what school is that child in right now? Maybe we better really make sure wherever that child's going to be placed, they can stay in that same school. Somebody paying attention to that. Placement stability. Now it's required to come to the court and tell the court, the agency must tell the court if they have a plan to move that child. It used to be that the child could be moved from foster home to foster home, and 3 or 6 months later, we'd see this child, and where was that child moved? Now they have to come to the court and ask, and that's a very big change. And sometimes we have very long hearings on this one versus this one. Incredibly important for stability for children.
Every time a child
I'm
is,
sorry?
I'm sorry, every time a child is moved to a different
Yes.
place, it has to come before a
Yes,
judge.
come to the court. What we do is in Allegheny County, it's a motion. And if it's going to be a hearing, it's going to be a hearing. There are conflicting choices to be made at that point. Yeah. Otherwise, if everyone agrees, then that child goes there. But the court has to look at it and enter an order. That's part of how process can drive practice. And I think the rules really are the place where process drives the practice and raises up what we think is better for kids to a mandate for judges to look at.
If I could just expand on that, the only exception is an emergency. A child can be moved in an emergency, but within a number of hours, that has to come before a court, and that has to be authorized by the court.
We actually also have to authorize it in our county. They call us, and we're on call. So they call us in the middle of the night, they bring a child somewhere, and we have to approve it. And that has helped to drive other practice, because one of the, I'm sorry, we just left off with you. The other concept was that children are better off in their families, extended, big picture family. That could be the next door neighbor, but they're better off there. And so we get the call in the middle of the night, and they have to move a child. It's a big domestic violence situation. The child's unsafe, can't stay there. Both parents are getting arrested. My first question is, tell me where you're thinking about this child going. Who have you asked? Did you talk to the parent before they got hauled off by the police? Go talk to the parent in the jail. I want to figure out, where can this kid go that's not a stranger? Because we know that we screw up every kid that we yank from their little world and put them, even if we think we're doing great work. We all think we're doing great work. But if we put that child in another whole world, we screwed up their friends, their education, all those kinds of things.
So for many years in the past, parents would sign voluntary placement agreements, and their children would be placed in foster care on a voluntary basis. How often is that done now? And if it is still done, does the judge still know about it if the child has to then get placed again?
Mark, I'm going to have to defer to you because we wouldn't see that.
I think it's pretty rare. In Allegheny County, we don't do it much at all. But I think if you go across the 67 counties, it varies. And I'm a proponent of not doing voluntaries. If it goes to court, because then there is the checks and balances. There's a lot of ways to coerce parents if you do it voluntarily.
Data on that? Like, is there data on
We don't.
That's
We
part of.
probably get it based on self-report.
Yeah, and it's one of the issues I'm sure you've heard about, like, since there's no statewide SAFRA system, no child welfare system, things really vary in terms of how folks capture things, and that has very limited ability. It had to bring 67 counties together, which doesn't have a system that mandates that. That's a huge issue across that would help tremendously.
The other thing on voluntaries, we do allow for a 30-day voluntary, nothing past that.
The advantage, again, with the data piece is that if it comes to court, and we are driving this by data, because we have a statewide data collection system we're going to be talking about that is now in every county, and our data is starting to come out much cleaner now as people have been trained adequately. Inputting it, we're getting better at it. So we're going to be able to track a lot of these subtler pieces related to what happens to kids that we've never been able to track before.
Would there be a reason, we see a lot of volunteers, I don't think they're mostly Allegheny County, they're mostly our surrounding counties. We do see a lot of voluntary placements, and the 30 days gets extended multiple times, so that it's actually more than 30 days, right? Because something happens, it's a 30-day extension on the voluntary.
There should never be a 30-day extension.
But is there an argument, I guess what I'm asking is there an argument to put those through the court system to at least get a sense of how many there are, or would it overwhelm the system? Because I think the issue is, once a child's in placement, shouldn't someone have oversight, whether it's voluntary or not voluntary?
Yeah, I mean, I don't think it would overwhelm the system at all, but I think it's really important that kids have a guardian ad litem in these kind of situations, because they are in placement, whether voluntary or not, and the parents have representation. So a lot of times, you know, without all due respect to workers, you know, it's real easy to say, your child's going in the placement, you know, we're going to do it unless you sign voluntarily. And then you don't really have rights in terms of how to get your kids back. And oftentimes it can get delayed. It can be misused. And when you're in the court system, I mean, that comes with other stuff, but it's still, you have the checks and balances then, you know, and that you really are tracking the judge, you know, when making the call. And And the way we do it now, it's not really adversarial, dependency court the way it used to be, so it's much more of a helping kind of situation. So I would really limit them if using them at all.
Just to flip that for a moment, other than expediency, is there any advantage to voluntary placement in your opinion?
Well, I mean, what folks would say is that it's a positive thing, parent